Okay, very briefly, what do we know about the use of conferencing models in sexual assault? Not widely used in sexual assault cases to date. Hardly ever used actually in terms of adult offenders, but conferencing is used for sexual assault where the offender is a juvenile. For example, I note here South Australia and New Zealand have had procedures in place now for more than 10 years, or 10 to 15 years, which are seen as being quite productive and effective. Also in reducing reoffending, and I won't go into the detail of that now. There has been one program running in the US called RESTORE, which is an acronym for Responsibility and Equity for Sexual Transgressions Offering a Restorative Experience. And so we call it RESTORE. Okay. And RESTORE operated for some years in Arizona, did involve adult offenders being referred by the prosecution, so that it was in the model that I was also describing, where you have the prosecution case that begins, the prosecution makes a decision as to which cases might be appropriate for this conferencing model, and it proceeds there, and there's quite a bit of literature on that. Interestingly, sadly probably, the program has recently been defunded, wound down, and one argument that was put to me by one academic who's been doing a bit of work with the people who ran RESTORE was that once an offender realised that the prosecution, this was her interpretation, once the offender realised that the prosecution thought it would be too hard to prosecute, so it might as well go to conferencing, the offender knew that they were going to get off, if they were almost certain to get off, because it was such a difficult case to prosecute. So then they'd say, no, I don't want to go to conferencing, I want it to go to trial, because they felt they had a particularly good chance of acquittal. And this is the dilemma in this area, the practical dilemma. Okay, some practical challenges, just to noting those. Will victims want to participate? That will be an issue. Will defendants acknowledge responsibility? If they believe that a denial will lead to a full acquittal, what will be the incentive? And this is where the incentive may arise in the benefits that can be achieved by a conferencing model, that the defendant has to be satisfied that they will get both a fair hearing and also a chance to have the matter finalised without the risk of conviction. Procedures have to be put in place to ensure that the power imbalances, which are the basis of most sexual assault, are not sort of reintegrated into the process itself. So issues of power imbalance are of great concern, and in the way in which the procedures are set up and the protections that are put in place, because you would not ever want to set up an alternative process which actually re-victimises the person even more. Which cases, again, the challenge will be to decide what are the most appropriate cases, both from the community's perspective, what do we think is acceptable, but also from the point of view of victims and offenders. And as I mentioned, there may be specific categories of case where this is going to be seen as much more appropriate than in others. And there's also the issue of resourcing, she says, with a drop of the voice at the end. It's just resourcing, but actually resourcing is really important because these sorts of processes are going to be quite resource intensive to be done properly. Okay, so there will be clearly matters of getting proper resourcing. A key issue here, which I will only flag because of time, is to note we do have that question, so where's the punishment? Where's the retribution? Is this going to be a process that is acceptable from that point of view? And I would just note there that this has been a subject of considerable debate, but many writers in this field do take the view that it is quite possible for a person to experience a number of the features of punishment. I mean, we could have a debate all day about whether we believe in punishment, what it is, and whether it should happen at all, and what amounts to punishment. But it has been pointed out that that conferencing model that I've outlined does include the scope for inducing remorse, does include the imposition of censure, if you've got that community voice present, able to say that was a really bad thing to do, this is not something we accept, and does also provide for some form of reparation. So remorse, censure and reparation as parts of the punishment paradigm or concept that we apply in the court system may be potentially achievable through this model as well in some situations. Of course, I just note there that middle one, the censure one, as many people have pointed out, in communities and societies which still endorse male violence to women and the commodification of women, we may not get that community censure in the conference model either. I mean, the community from which the offender comes may in fact continue to endorse that offenders' behaviour, and that's a challenge as well, and it's a challenge for the broader community and its attitudes to women and to male violence. The status of the conference outcome, what's it going to be? If it's not going to be a conviction, is it going to be recorded anywhere? You know, what does that mean as well? So there's a number of issues there that are going to become relevant then to the actual model. And I'm not going to go into a lot of detail on the model. I think what I've talked about is the sort of conferencing, the sort of classic or ideal restorative justice conference model, the private room, the family, the supporters, the individuals, no public outcome. Okay, an outcome for the parties, we'd hope, but nothing that will get into the press or be reported. But there may be ways of linking that sort of ideal model back into the court process, for example, through the growing use of problem-solving courts, or courts which have got a more therapeutic or restorative framework in which they operate, where they may have more ongoing work with the parties over a period of time to reach an outcome. There are a number of ways in which I guess we've got hybrid models that might be able to incorporate some of these concepts, some of these benefits, but without losing the power of the court process and the formalised resolution in some of these cases. So that's where I'm leaving it. It's sort of a downer at the end saying, I don't actually know how one would do this. I think there are a number of ways of thinking about doing it, but I actually think that the debate has to be had. And as I said at the beginning, the experience we've had so far of the limitations of the criminal justice system for victims in this category of offence are so obvious that I don't think we cannot have a debate about alternative pathways. Thank you.
Well, I think there certainly is a debate to be had, and that the idea of a sexual offender and a victim sitting across the table and discussing the offence is just so surprising to a lot of us that I'm sure there will be a lot of questions. So I'd encourage you to jot those down and keep them for Bronwyn later. Also, I think it's very interesting, Bronwyn, that you highlighted the fact that law reform can't happen in a vacuum, and that perhaps the failures of these rape law reforms are that social change has not accompanied them, and that really what we're talking about today is not so much just law reform but social change as well. Which brings us to our next theme, which is an area in which we need both law reform and social change. I'd like to introduce our final speaker on this panel, Paula Gerber. Gerber. I've practiced that so many times in my head and it just came out wrong. My apologies, Paula. Paula has practiced law both here and overseas and is now one of the directors of the Caston Centre for Human Rights. And she is author of a new book entitled Current Trends in the Regulation of Same-Sex Relationships. And I'd like to introduce Paula. Thanks, Paula.
Now, which buttons am I pushing? Which buttons? That one? Okay. Okay, well, thank you very much for the opportunity to speak here today. I perhaps begin by saying that I am coming to this topic from a human rights perspective. There are a number of different ways that you can look at same-sex marriage. My colleague Adiva Sifris, who I've edited the book with, is very much a family law practitioner. Family law focus is where she comes at same-sex marriage. There are others who come at it from a constitutional law issue. But I'm very much coming at it today from the human rights framework. And what I want to discuss today is there a right to marry in international human rights law? And I'm going to look at 3 human rights treaties in particular. If yes, is that limited to heterosexual marriage? And there's a lot of debate and discussion about civil unions and about domestic partnership, relationship registries, things like this. Are they enough? If not, why not? And finally, sort of at the end, draw all that together to say what's the implications for Australia, where this is obviously a very hot topic. But before I get into the international human rights law, I'd like to remind everyone that marriage is a social construction. As William Eskridge famously said, marriage is an institution that is constructed, not discovered by societies. The social construction of marriage in any given society is fluid and mobile. And, most of you will recall from the history books when people of different races were not allowed to marry each other. When white settlers came to Australia, a man whose wife died was not allowed to marry his sister, the wife's sister. That was duly reformed. And the social construction of marriage was recently brought home to me when a friend of mine in Sydney, who's working with children with disabilities, started to notice that within the Lebanese community there seemed to be a high number of children with disabilities. And further inquiries reveal that this is because in Lebanese culture it is perfectly acceptable for first cousins to marry. And I started doing a bit of research on this and realised that, there are a lot of very different laws all around the world about cousins marrying. And certain states in America allow cousins to marry if they're no longer of child-producing age, or if they can show that one of them is infertile. These sort of all represent the social construction of marriage, and same-sex marriage falls very clearly within that sort of debate. So when you're looking at things from a human rights perspective, you always begin with the Universal Declaration of Human Rights, 1948, and Article 16 of that says, men and women of full age without any limitation of race, nationality, religion have the right to marry and found a family, and they're entitled to equal rights as to marriage, during marriage and at its dissolution. So that doesn't actually say only men and women can marry each other. Does refer to men and women, but not that they have to marry each other only. Now, any of you who've studied human rights law or have a basic knowledge will know that the UDHR, being a declaration rather than a treaty, is not, strictly speaking, binding on states. So steps were taken to transform the rights in the UDHR into binding international laws, and Article 16 of the UDHR became in effect Article 23 of the ICCPR, the International Covenant on Civil and Political Rights. And I'll give you a moment to read that. And whilst you're doing that, perhaps I'll point out that this is the only article anywhere in the ICCPR that refers to men and women. Every other article says or persons or every human being, and uses general language that's all-encompassing. But Article 23 talks about the right of men and women of marriageable age to marry and to found a family. So that obviously raised the question, well, what does this actually mean? And that was tested in 2002 in the case of Jocelyn in New Zealand. Now, as many of you may know, if you as an individual feel that a right of yours has been breached, a right set out in the ICCPR has been breached, has been violated, and you've exhausted all your domestic remedies, then you can bring a complaint to the Human Rights Committee, which is a UN treaty body that will hear and determine complaints for alleged violations of the ICCPR. So Jocelyn in 2002 brought a complaint against New Zealand, saying that their rights under Article 23 of the ICCPR had been breached because the New Zealand Marriage Act provided only for the marriage of men and women.